Hello and welcome. I am Roberta Reardon, Commissioner at the New York State Department of Labor. Thank you for joining today as we discuss important topics on cannabis workforce responsibility. This is just one step on your way to a rewarding career in New York's cannabis industry. Let's get started.
Congratulations and welcome to the New York State cannabis industry. We have designed this training to help you understand some of your rights as an employee in this new and exciting industry. In this training, we will cover labor standards, protections, benefits eligibility, and other information about your employment. In New York, adult-use cannabis businesses must provide responsible workforce training to all managers, employees, contractors, volunteers, or persons otherwise performing activities under a licensee's authorizations within 30 days of that person starting to perform those activities. The responsible workforce training must include a cannabis product safety and responsibility course as determined by the Office of Cannabis Management, a cannabis workforce responsibility course also as determined by the Office of Cannabis Management, implicit bias training or cultural competency training that lasts at least 1 hour, and at least 2 hours of other training intended to assist employees in conducting the business's licensed activities in a manner that protects employee and public safety. This responsible workforce training module satisfies the Cannabis Workforce Responsibility course and is meant to help you understand the laws and rules regarding cannabis, worker safety, labor standards, and cannabis perceptions. This foundational course was developed in partnership with Governor Kathy Hochul's administration, the New York State Office of Cannabis Management, and the New York State Department of Labor. In addition to this responsible workforce training, Office of Cannabis Management regulations require that employers provide employees with separate training on occupational health and safety, hazard communication, and proper use of chemicals and materials. And employees of delivery, dispensaries, and on-site consumption licensees must receive separate training on workplace violence. This module is not a comprehensive guide to cannabis or working in cannabis. It is an introduction to your labor rights as a cannabis employee and is intended to provide you with the basic knowledge to enter work in the cannabis industry. This training is not meant to serve as legal advice. We are providing information so that you are aware of legal considerations around cannabis and employment. You should speak with a legal professional if you have any legal questions. As laws, regulations, and information change around cannabis, we will continue to update this training. After completing this Cannabis Workforce Responsibility module, participants will be able to Objective 1. Explain the roles of the New York State Office of Cannabis Management and the New York State Department of Labor as it relates to cannabis and working in the cannabis industry. Objective 2. Understand the basics around working in New York's cannabis industry, including cannabis worker eligibility requirements, adult use and medical cannabis at work, labor standards and worker rights, and discrimination. Objective 3. Explain workplace health and safety standards, including helping to limit the risk of biological, chemical, and physical hazards, workplace violence, alcohol-free, drug-free, and smoke-free workplaces, and behavioral and mental health. Objective 4. Understand cannabis perceptions. In order to help you understand and apply the information discussed in this video, we have included knowledge checks. The knowledge checks are in a separate PDF document, which you may fill out and compare to the provided answer key to test your knowledge of the content. Each person who completes the Responsible Workforce Training is required to complete the Responsible Workforce Training attestation form, save a copy for their records, and submit a copy to their employer for the licensee's records. Licensees must maintain all submitted attestations and be able to demonstrate completion of the Responsible Workforce Training by each required employee upon request by the Office of Cannabis Management. The Office of Cannabis Management, with oversight from the Cannabis Control Board, is the state agency responsible for regulating all aspects of the adult use cannabis, medical cannabis, and cannabinoid hemp industries in New York. This includes issuing and renewing business licenses and permits, creating and enforcing rules and regulations, and inspecting business premises and records. We are your DOL. Our mission is to provide outstanding services to our customers, the workers and businesses that call New York home. We help New Yorkers find the careers they will love by connecting them to employment, training, and upskilling opportunities. We build and support New York's businesses, helping them find qualified workers and keep them informed about tools and incentives to make their businesses thrive. And we empower and protect New York's workers by supporting the unemployed and by ensuring all workers have a safe workplace where they receive wages for all hours worked. We have 95 career centers across the state where we serve 500,000 job seekers and 30,000 businesses per year on average. The New York State Department of Labor also enforces state labor laws for minimum wage, hours of work, employment of minors, payment of wages, farm labor, right to express breast milk in the workplace, and more. We can issue fines and penalties as well as investigate complaints regarding labor law violations. To work in the cannabis industry, you must be at least 18 years old. Employees under 21 may not deliver cannabis products to consumers or have direct interaction with customers inside of a retail dispensary or on-site consumption space. Additionally, you must be able to legally work in the United States to work in the cannabis industry. Everyone is responsible for making sure they have the proper visa or work authorization before seeking employment. While New York regulates cannabis businesses within the state, cannabis is still illegal in the eyes of the federal government. Everyone working in the cannabis industry should consider the risks involved, including potential risks to their immigration status. In New York State, employers are prohibited from discriminating against employees because of their adult use of legal substances outside of working hours, including cannabis. Discrimination occurs when an employer makes decisions relating to hiring, firing, privileges, or other terms of employment based on adult use of cannabis. Exceptions include instances where the employer's actions were required by state or federal law, or the employer suspects the employee is impaired while working. Employers can take disciplinary action against someone for being impaired during work hours if it lessens the performance of their duties or interferes with an employer's obligation to provide a safe and healthy workplace. Employers can act against someone using cannabis while at work, even when on break, or possessing cannabis or cannabis products on employer property. And employers can prohibit employees from bringing cannabis onto the employer's property, including office space, company vehicles, and areas such as lockers, break rooms, and desks. In New York State, medical cannabis patients are protected from discriminatory action based solely on their status in the medical cannabis program. However, use or impairment on the job is not a protected activity. If you feel you have experienced or witnessed a violation of New York labor law involving adult use cannabis at work, you can file a complaint directly with the New York State Department of Labor, Division of Labor Standards by filling out a Labor Standards complaint form by emailing lsask@labor.ny.gov or calling 1-888-52-LABOR for additional information. It's important to know that employers can't retaliate against their employees for reporting labor law violations. More on this later. If you feel you have experienced a violation of New York human rights law involving medical cannabis at work, you can file a complaint directly with the New York State Division of Human Rights by filling out an employment complaint form. If you have witnessed a violation of New York human rights law, you can provide that information to tips@dhr.ny.gov. Like any business in New York State, cannabis businesses must follow all state and federal labor laws and regulations.
As an employee, you are entitled to wages for all hours worked, sick and safe leave, a safe work environment free from harassment, and other worker protections.
Information throughout this video explains your rights as a cannabis employee. For additional information on the labor standards discussed in this training, be sure to visit the Department of Labor's website at dol.ny.gov. You have the right to find out labor law requirements, file a complaint with the Department of Labor, pursue all wages owed to you either through the Department of Labor or through private legal action, give information to the Department of Labor, answer truthfully when interviewed by a Department of Labor investigator or inspector, testify in an official proceeding under the labor law, not be retaliated against, punished because you reported violations or exercised any of your rights under the labor law. And it's important to know that all workers have these rights regardless of their citizenship or immigration status. In New York, a private employer may terminate your employment without good cause unless it's for an illegal reason. It is possible that your employment contract may have language protecting your employment. However, this type of language is not required. Some reasons for termination are not legal. These include discrimination, complaining about labor law violations, whistleblowing, participating in lawful political or recreational activities outside of work, joining or forming a union at work, and otherwise exercising your ability to use paid sick and safe leave, jury duty, and other forms of job-protected leave such as family and medical leave. It's important to know that if you believe you have been terminated for an illegal reason, there are remedies available to you.
All New York workers are entitled to receive, at minimum, an hourly minimum wage. The minimum wage rate varies depending on where you work and the type of work you do. As of January 1st, 2025, the minimum wage in New York City, Long Island, and Westchester is $16.50 an hour, and in the remainder of the state, the minimum wage is $15.50 an hour. Additionally, rates in all counties will increase by 50 cents an hour on January 1st, 2026. Beginning in 2027, the minimum wage will annually increase by the 3-year moving average of the Consumer Price Index for urban wage earners and clerical workers for the Northeast region. To learn more, visit the Department of Labor's website at dol.ny.gov.
It is important to know that you should not be compensated in cannabis product. Manual workers must be paid weekly and other workers at least twice per month.
Employers in New York State must provide all employees time off for meals after working a certain number of hours. In general, employers must provide at least 30 minutes of unpaid time off for a meal if an employee works more than 6 hours in one day.
Pay equity prohibits unequal pay on the basis of a protected class for all substantially similar work. Protected classes include, but are not limited to race, color, gender identity, nation of origin, religion, sex, disability, and age. Overtime is 1.5 times your regular hourly rate 4 hours over a particular threshold on a weekly basis.
For farm laborers, which includes those working in cannabis cultivation, the threshold for overtime pay changed in January 2024 to 56 hours in a week. In January 2026, the overtime threshold will change to 52 hours in a week and will be gradually reducing every 2 years from there to 40 hours in a week by 2032. If your job involves non-cultivation work only, or both cultivation and non-cultivation work, your overtime rate would begin at 40 hours a week.
Employers are required to provide the following notices to employees: wage statements or pay stubs, pay notice, which is a notice of pay rates and pay day at hiring and when any changes are made, notification of fringe benefits and hours, and termination notice, which is a written notice to an employee within 5 business days of termination. Employers may be required to withhold federal payroll tax and federal, state, and local employment taxes. The New York State Department of Labor's Division of Labor Standards ensures employers in New York State do not make illegal deductions from workers' wages for cash shortages, breaking equipment, damaging product, fines, losses to the business, charges for check replacement, or overcharges for paid family leave premiums. Deductions from wages for pay advances or overpayments are only legal if they are made in accordance with the law. Employers are required to pay unemployment insurance, which could entitle you to benefits should you be terminated from your job at no fault of your own. The New York State Department of Labor administers New York's unemployment insurance system, including the handling of claims, weekly certification, and payments. Your employer must pay workers' compensation insurance that entitles you to benefits should you be injured while working. To learn more about workers' compensation, visit the Workers' Compensation Board website at wcb.ny.gov. New York requires employers to provide disability and paid family leave benefits coverage to employees. Disability benefits provide paid time off to recover from an off-the-job injury or illness. Under disability benefits coverage, the law provides for the payment of cash benefits to employees who become disabled because of injuries or illnesses that have no connection to their employment, such as disabilities arising from pregnancies. The law does not provide for the payments of medical care. To learn more about disability benefits, visit the Workers' Compensation Board website at wcb.ny.gov. Under New York paid family leave coverage, the law provides job-protected, paid leave to bond with a new child, care for a loved one with a serious health condition, or to help relieve family pressures when a family member is called to active military service abroad. The law allows, but does not require, an employer to collect contributions from its employees to offset the cost to provide the paid family leave benefit. To learn more about paid family leave, visit the Paid Family Leave website at paidfamilyleave.ny.gov. The Affordable Care Act was designed to expand access to insurance coverage, increase consumer insurance protections, and emphasize prevention and wellness. Large employers must provide sufficient and affordable health care coverage to any employees who average at least 30 hours per week or 130 hours per month. Large employers must pay a penalty for not offering coverage that is affordable and pays for at least 60% of covered benefits. Small employers must report the value of the health insurance coverage provided to each employee on their W-2 form. For self-insured health coverage employees, employers must file an annual return reporting the health insurance benefits provided. Small employers are required to withhold and report an additional 0.9% of employee wages exceeding $200,000. Cannabis license holders in New York must maintain a labor peace agreement with a bona fide labor organization. A labor peace agreement is an agreement between an employer and a labor organization that, at a minimum, prevents labor organizations and members from engaging in picketing, work stoppages, boycotts, and any other economic interference with the employer's activities. For employees of a cannabis business, this means they may have union representation. Unions play a major role in impacting the lives of workers through ensuring worker safety protections exist, setting standards for hiring and wage increases, career mobility, and overall workforce development. Make sure to check if a union represents the employees where you work. It's always a good idea to be aware of and understand any collective bargaining agreement that may exist between your employer and a union, since it can have a direct impact on your employment and career growth. It's important that you understand whether you are an independent contractor or employee when working for any business. Regardless of whether your employer calls you an independent contractor, you may have rights as an employee. An employer may genuinely believe that they have hired someone to perform services for them as an independent contractor. Employers may discover that by law these individuals are considered employees and that the employer is liable for unemployment insurance contributions and other employee benefits. Whether the relationship is one of employer-employee will depend on several factors. These include how much supervision, direction, and control an employer has over the services being provided.
A non-competition agreement, or non-compete, is a contract that prohibits or restricts an employee from obtaining employment in a specified geographic area for a specified amount of time with a particular employer or in a particular industry.
A non-compete may be one section of an employment contract or a standalone contract that an employee signs before or after employment begins.
A non-compete is only allowed and enforceable to the extent that it 1. Is necessary to protect the employer's legitimate interests. 2. Does not impose an undue hardship on the employee. 3. Does not harm the public. And 4. Is reasonable in time period and geographic scope. Depending on the terms of an agreement, a non-compete may limit your ability to accept a new job for a certain period of time within a certain geographic area.
You are not required to sign a non-compete. However, there may be instances where you are told by an employer that you must sign a non-compete to be hired or continue employment.
You may sign a non-compete, but you should always check to see whether the agreement is enforceable. If you have questions about non-compete agreements, you should contact a legal professional.
New York state law requires employers with 5 or more employees or net income of more than $1 million to provide paid sick leave to employees.
Employers with fewer than 5 employees and a net income of $1 million or less must provide unpaid sick leave to employees.
Employers must provide 40 to 56 hours of paid or unpaid sick leave per calendar year, depending on the number of employees. Sick leave can be used
for mental or physical illness, injury, or health conditions, regardless of whether it has been diagnosed or requires medical care at the time of the request for leave.
For the diagnosis, care, or treatment of a mental or physical illness, injury, or health condition, or for a need for medical diagnosis or preventative care. Safe leave can be used for an absence from work when the employee or employee's family member has been the victim of domestic violence, a family offense, sexual offense, stalking, or human trafficking. This includes an absence for meeting with an attorney, district attorney, or other social services provider to obtain information or advice, obtaining services from a domestic violence shelter, rape crisis center, or other services program, filing a complaint or domestic incident report with law enforcement, or enrolling children in a new school. An employer cannot retaliate against an employee in any way for exercising their rights to use sick and safe leave. Employees must be restored to their position of employment as it had been prior to any leave taken.
Under New York paid family leave, New York state law provides workers with up to 12 weeks of job protection at 67% of your weekly wage, continued health insurance, and protection from discrimination or retaliation.
As mentioned earlier when talking about paid family leave, employees are eligible for job-protected paid time off to bond with a newly born, adopted, or fostered child, care for a family member with a serious health condition, or assist loved ones while a spouse, domestic partner, child, or parent is deployed abroad on active military service.
New York State paid prenatal leave law requires that all private sector employers in New York State provide their employees with 20 hours of paid prenatal leave each year to be used for prenatal healthcare service appointments during their pregnancy or related to their pregnancy. Under the Federal Family and Medical Leave Act, federal law provides job-protected, unpaid leave for employees for qualified medical and family reasons.
If an employee has an event that qualifies for leave under both the Family and Medical Leave Act and New York Paid Family Leave, and the employer is covered under both laws, the employer can require them to run concurrently or at the same time. In order for the two types of leaves to run together, the employer must notify the employee that the leave qualifies for both. If you feel you have experienced or witnessed a violation of labor laws, you can file a complaint directly with the New York State Department of Labor, Division of Labor Standards by filling out a Labor Standards complaint form, by emailing lsask@labor.ny.gov, or calling 1-888-52-LABOR for additional information. You can also file a complaint with the United States Department of Labor by calling 1-866-4-USA-DOL for violations of federal labor law.
Employers cannot retaliate against their employees for reporting labor law violations.
Retaliation is an action taken against an employee for complaining about labor law violations, providing information to the Department of Labor, or participating in proceedings at the Department of Labor. Retaliation can take many forms, such as being fired, having work hours cut, more intensive or critical supervision, threats to contact immigration, and more.
If you think you've been a victim of retaliation, contact the New York State Department of Labor by calling 1-888-52-LABOR or emailing lsask@labor.ny.gov.
Under federal and New York state law, discrimination occurs when you are treated differently in a way that causes an adverse impact to you. It includes
unfair treatment because of your protected status, such as race, religion, or sex.
Harassment by managers, coworkers, or others in your workplace because of your protected class. Denial of a reasonable workplace change that you need because of your religious beliefs, disability, or domestic violence victim status. Improper questions about or disclosure of your genetic information or medical information. Retaliation because you complained about job discrimination or assisted with a job discrimination proceeding, such as an investigation or lawsuit. As mentioned at the start of this module, the Office of Cannabis Management also requires implicit bias or cultural competency training for anyone performing activities under a cannabis license's authorization, which will cover many of these topics. Preventing discrimination is part of our mission. One way to promote anti-discrimination is through an active and continued commitment to diversity, inclusion, and equal opportunity practices. Most employers with at least 15 employees, labor unions, and employment agencies are required to comply with equal opportunity laws. Equal opportunity laws apply to all types of work situations, including hiring, firing, promotions, harassment, training, wages, and benefits. New York State human rights law and the Federal Americans with Disabilities Act protect people with disabilities from discrimination in employment. Employment discrimination is prohibited, and employers are required to provide reasonable accommodations for employees with disabilities. It is illegal for an employer to ask a potential or current employee if they have a disability. The employer may ask the potential or current employee if they can perform the major functions of the job. This will give the employees a chance to let an employer know if they need a reasonable accommodation. The employer is obligated to make reasonable accommodations that you request unless it results in undue hardship for the employer. Sexual harassment is a form of discrimination. Your employer is required to establish a sexual harassment policy that meets minimum standards, provide annual training, and provide a complaint form for their employees. In addition to your employer's internal complaint process, you have a right to pursue other legal remedies, including filing a complaint with local law enforcement. You have a right to express breast milk at your place of employment in an environment that does not discourage breastfeeding, chest feeding, or pumping.
Employers must provide 30-minute paid breaks each time an employee has a reasonable need to express milk for up to 3 years following childbirth.
Your employer must make reasonable efforts to provide a room or another location near your work area where you can express milk in private. Your employer may not discriminate against you based on your decision to express breast milk at work. If you feel you have been discriminated against, you can file a complaint directly with the United States Department of Labor Civil Rights Center, the United States Equal Employment Opportunity Commission, the New York Division of Human Rights, local authorities such as the New York City Commission on Human Rights for those working in New York City, and local law enforcement for sexual harassment claims. Worker health and safety are a top priority for the state of New York. While cannabis workplace health and safety requirements are similar to other industries, there are some special considerations to keep in mind and be aware of with cannabis workplaces. As a reminder, in addition to this responsible workforce training, Office of Cannabis Management regulations require that employers provide employees with separate training on occupational health and safety, hazard communication, and proper use of chemicals and materials. And employees of delivery dispensaries and on-site consumption licensees must receive separate training on workplace violence. This training is meant to be an introduction to workplace health and safety standards and is not a substitute for other safety and health training required by OSHA or any other regulatory body with jurisdiction. It's important to know that employers must provide employees with a workplace free from recognized hazards. It is illegal to retaliate against an employee for exercising any of their rights under the law, including raising a health and safety concern with their employer or with OSHA, or reporting a work-related injury or illness. Employees have the right to file a complaint and request a confidential OSHA inspection of their workplace if someone believes there are unsafe or unhealthy conditions. OSHA can be contacted at 1-800-321-OSHA 6742 or at www.osha.gov. It's important to be aware of biological, chemical, and physical hazards, their effect, and how to eliminate or reduce risk.
Biological hazards include mold, fungi, exposure to allergens, and sensitivity to the cannabis plant itself, including growing plants or dried or ground plant material.
Effects can include a skin rash, eye irritation, difficulty breathing, including exacerbation of pre-existing asthma, nasal congestion, coughing, throat irritation, or other serious illness or injury.
There are hazards associated with chemicals used in many aspects of the cannabis industry, such as plant nutrients, extraction solvents, raw ingredients for product manufacturing, dusts, gases, and vapors generated during handling and processing, pesticides, cleaning supplies, lead, silica, and asbestos.
The effects of these chemical hazards can be extremely serious, including burns, poisoning, skin or eye irritation, dizziness, or serious illness or injury. Physical hazards also exist and can include flammable, combustible, and compressed gases and liquids, sharp objects or tools, hot or cold work environments or work surfaces, pressurized equipment, electricity, noise, intense white and or UV lights, spills, slips, falls, confined spaces, unmarked gaps and steps, injury from contact with operating machinery, dangers from working on or around farm, industrial, or over-the-road vehicles, musculoskeletal injuries from lifting heavy objects, repetitive motions or awkward postures, working at heights, and other hazards. Effects of physical hazards include burns, cuts, infections, or other serious injuries. Controlling exposures to hazards in the workplace is vital to protecting workers. There are many ways to limit exposure and effects of workplace hazards. The hierarchy of controls is a way of determining which actions will best control exposures to hazards. The hierarchy has 5 levels of actions to reduce or remove hazards. The preferred order of action based on general effectiveness is 1. Elimination, 2. Substitution, 3. engineering controls, 4. administrative controls, 5. personal protective equipment or PPE. Controls that do not require human intervention are generally the most reliable. As a result, PPE should be used as a last line of defense and in combination with other more reliable controls. Examples of controls to reduce or remove hazards include, but are not limited to, regular cleaning and housekeeping, using proper monitoring and alarm systems, providing adequate ventilation, ensuring proper use and access to personal protective equipment or PPE, maintaining proper labeling and storage of raw materials, providing access to safety data sheets, conducting equipment and building preventative maintenance, providing readily accessible restrooms that are maintained in a sanitary condition, maintaining unobstructed access to working fire extinguishers, eyewash stations, and emergency electrical disconnects, providing hazard awareness training on bloodborne pathogens, working to prevent slips, trips, and falls, and following plans for workplace safety and emergency evacuations, as well as complying with applicable state and local fire safety, health, water, building, and zoning codes, regulations, laws, and guidance. Immediately seek medical attention if you develop a rash, have difficulty breathing, are injured, or feel any other effects for any reason, including potential exposure to workplace hazards. Early reporting is important because sometimes some symptoms, such as occupational asthma, can develop and symptoms can worsen with continued exposure. According to the U.S. Occupational Safety and Health Administration, or OSHA, workplace violence is any act or threat of physical or verbal violence, harassment, intimidation, or other threatening disruptive behavior that occurs at the worksite. All workers are at risk of workplace violence, but there are some specific circumstances with cannabis businesses that may increase the risk of workplace violence in the industry. Because cannabis can involve paying or receiving large amounts of cash, workers and workplaces can become vulnerable to attempted robberies or other criminal enterprises. Like cash, cannabis and cannabis products are extremely valuable. As a result, workers and workplaces can be the target of robberies or other theft. Unhappy employees or former employees can also be a risk factor for workplace violence. Like any business, workers in the cannabis industry may feel stress from clientele, coworkers, and workplace expectations. High-stress environments can increase the risk of workplace violence as well. Best practices for reducing the risk of workplace violence include: have a workplace violence prevention plan that includes steps for assessing and addressing risks, emergency procedures, seeking help, training, and opportunities to update the plan for additional risks. Always follow your employer's security and safety protocols, whether handling, overseeing, or transporting cannabis, cannabis products, or cash. This includes following requirements for proper handling and transportation, and making sure to follow surveillance and other security equipment protocols. Always report suspicious behavior to a supervisor immediately. There are best practices to follow when responding to workplace violence that is occurring or has already occurred. Never engage someone that is acting violently at the workplace, regardless of whether they're a fellow employee or a stranger. Call the police and wait for assistance. And report any violence you witness, hear about, or encounter to a supervisor immediately. It's important to know that New York's Clean Indoor Air Act prohibits smoking and vaping in private indoor workplaces to protect workers and the public from exposure to secondhand smoke and vaping aerosols. Cannabis on-site consumption facilities, as approved and regulated by the Office of Cannabis Management, will allow smoking or vaping but must comply with indoor air quality standards. Office of Cannabis Management regulations require that cannabis license holders maintain an alcohol-free, drug-free, and smoke-free workplace. And as mentioned earlier, all employers can prohibit employee cannabis possession and impairment on the job. There are several New York State, local, and federal agencies that are involved in the enforcement of worker health and safety standards. These agencies include, but are not limited to, New York Office of Cannabis Management, U.S. Occupational Safety and Health Administration, also known as OSHA, New York Department of Agriculture and Markets, New York Department of Environmental Conservation, State, County, and Local Department of Health, State, County, and Local Police, and County or local fire, water, and building departments. In addition to your physical safety at work, behavioral and mental health are important factors in your overall well-being. For example, Stress, anxiety, and depression can affect your ability to secure and maintain employment. There are programs across New York State where you can find assistance. For more information, call the New York Project Hope Emotional Support Helpline at 1-844-863-9314. Also, substance use and addiction can impact your daily life and cause problems at work or home. You can find assistance with substance abuse or addiction by calling the Office of Addiction Services and Support's 24/7 New York Hope line at 1-877-8-HOPE-NY or texting 467-369, or by visiting oasis.ny.gov to learn more. Because of the history of cannabis prohibition and the fact that adult use cannabis was legalized in New York in 2021, opinions and perceptions around cannabis may differ. This is a big shift as decades of prohibition and misinformation have skewed the public's current understanding of the cannabis plant. An informed workforce can help reduce stigma and increase public knowledge of cannabis. People may perceive cannabis differently. And while in New York, adults 21 years of age and older may possess up to 3 ounces of cannabis and 24 grams of concentrated cannabis, like vaporization oil or an edible, it is still federally prohibited. Use discretion when discussing who you may have seen purchasing or consuming cannabis. Alcohol prohibition is a good example of perceptions changing around a previously illegal activity. In the early 1900s, during alcohol prohibition, the illegal manufacturing and sale of liquor and the smuggling of alcohol across state lines continued. With the country facing the Great Depression by 1932, people saw the benefit of creating jobs and revenue by legalizing the liquor industry. Alcohol prohibition ended less than 100 years ago and is now seen as any other industry. Very likely, cannabis will ultimately be as accepted as alcohol. Cannabis business owners, workers, and consumers come from a variety of experiences and backgrounds. Everyone should conduct business in a manner that respects, relates to, and responds to an individual's culture by gaining awareness of and addressing bias.
As mentioned earlier, to support a diverse, inclusive, and equitable cannabis industry and workforce in New York, the Office of Cannabis Management also requires implicit bias or cultural competency training for anyone performing activities under a cannabis license's authorization, which will cover many of these topics.
This exciting industry is creating a lot of positive changes through new employment opportunities, righting the wrongs of cannabis prohibition, and helping people access the benefits of cannabis. With this module of the Responsible Workforce Training, we have provided you with a foundation of knowledge to help you better understand the basics of working in cannabis, as well as your rights to safe and fair employment. To learn more about working in the cannabis industry, starting your own cannabis business, or more information on the topics we covered, please visit these websites: dol.ny.gov, dol.ny.gov/cannabis, cannabis.ny.gov. Thank you for taking the time to educate yourself today, and congratulations on beginning your career in cannabis. I wish you the best of luck.